My name is Sarah Mitchell. I am 38 years old. And on a cold Tuesday morning in November, I walked into a federal courtroom in Chicago wearing the only blazer I still owned, the one I had bought 6 years earlier to celebrate the day my company was born. The company that was now being defended against me by a man in a $3,000 suit. His name was Victor Langley. He was the top litigation partner at one of the most powerful law firms in the city. He had won cases for Fortune 500 companies, cleared charges against CEOs, and reportedly never lost a business dispute in 11 years. He looked at me across the courtroom that morning the way a person looks at something small in their path, not with anger, not even with disrespect, just with complete indifference. And then, about 20 minutes into the hearing, he turned to face the courtroom, pointed directly at me, and laughed. Not a small laugh. A real one. "Your Honor," he said confidently, loud enough for everyone in that room to hear, "this woman has no evidence, no money, and no chance. This case is a joke." A few people smirked. Someone behind me whispered something. My own hands were flat on the table in front of me. I didn't look away. I didn't respond. Because I already knew something Victor Langley didn't. Before I tell you what happened next, please take a second to like this video, subscribe to the channel, and tell me in the comments what country you're watching from. Now, let's begin. 6 years before that courtroom, I was sitting in a coffee shop in downtown Chicago with a man named James Hartwell. James was charming, well-connected, and full of ideas that he never quite finished. I was a marketing director at a mid-sized firm, good at my job, careful with details, and, according to every performance review I'd ever received, the kind of person who made things actually happen. James had the vision. I had the execution. We shook hands over 2 cups of coffee and agreed to build something together. The company was called Viridian Solutions, a B2B software platform for small healthcare providers. James brought the investor connections. I built the product strategy, managed the development team, wrote every pitch deck, and spent the first 8 months working without salary because we agreed our equity split would be the reward. 50-50. That was the agreement. That was always the agreement. I have the emails to prove it. 47 of them. For the first 3 years, everything was exactly what we had planned. We grew slowly, then faster. We landed our first major client in year 2. By year 4, Viridian had over 200 clients and a valuation that made both of us sit quietly for a moment when we first saw the number. And that was when things started to change. It started small. James began introducing me to new investors as the head of operations instead of co-founder. Meeting notes started describing my role differently. Legal documents that crossed my desk had language I didn't recognize, language that quietly repositioned my title, my authority, my ownership. I raised it with James directly. He smiled and told me it was just administrative restructuring, that nothing was changing, that I was overthinking it. I wasn't. 8 months later, James presented me with a buyout offer, a number that was a fraction of what my 50% stake was worth. He told me, calmly and with that same smooth smile, that if I didn't sign, his legal team would demonstrate that I had never been a true co-founder, that I had always been a senior employee with performance bonuses dressed up to look like equity. I remember sitting in that conference room, in the company I had helped build from a handshake in a coffee shop, and feeling the floor disappear under me. I didn't sign. I hired a lawyer, a young attorney named David Park, fresh from a small firm on the North Side, who had honest eyes and a reputation for being meticulous. He couldn't promise me anything except that he would prepare. James's attorneys filed first, trying to preempt my claim. Victor Langley was lead counsel for the defense. The trial date was set for November. I spent those months preparing. David and I went through every email, every document, every contract from the beginning. But the strongest piece of evidence didn't come from me. It came from a woman named Karen Ellis. Karen had been James's executive assistant for 4 years. She was quiet, professional, and had watched everything that happened inside that company from closer than anyone. 3 weeks before the trial, she called me. She had heard what James had done. And she had kept copies of something she felt I needed to see, internal memos, written in James's own hand and sent to his personal legal team, in which he explicitly referred to me as co-founder and discussed strategies for, as he put it, reframing Sarah's role before this goes to court. She also had an audio recording. In it, James's voice was clear and unmistakable. "She doesn't have the resources to fight this," he said. "By the time we're done redefining her position in the company documents, there won't be anything left to argue." Karen handed over everything she had. "David and I didn't tell anyone. Not a word." The morning of the trial, Victor Langley walked in like a man who had already won. He set his leather folder on the table without looking around the room. His team, 3 associates in matching navy suits, arranged themselves beside him with practiced efficiency. My side of the room was quieter. David and I. 1 paralegal. A folder of documents. A small USB drive sitting in my jacket pocket. Judge Robert Harmon entered the room. He was in his late 60s, silver-haired, with the kind of face that had seen every courtroom maneuver ever invented and was tired of most of them. The hearing began. Victor Langley opened his case with the confidence of someone reciting a script he had memorized long ago. Sarah Mitchell had been a valued employee. She had been compensated generously. Her claims of co-founder equity were unsupported, undocumented, and inconsistent with how the company had always been legally structured. He spoke for 12 minutes, without once glancing at me. When David began our opening, Victor interrupted 3 times in the first 5 minutes. Each time, Judge Harmon sustained the objection with a brief nod. Then Victor Langley stood up for his summary statement. He turned to face the room. He pointed at me, and he laughed. "Your Honor," he said, his voice carrying across every corner of that courtroom. "This woman has no evidence, no money, and no chance. This case is a joke." Someone behind me shifted in their seat. I heard a quiet sound from the gallery. Not laughter exactly, but something close. An exhale of agreement. I kept my hands flat on the table. I looked at Victor Langley, and I did not look away. David placed his hand on my arm and leaned close. "Now," he asked quietly. "Now," I said. David stood up. "Your Honor," he said calmly, "the defense has characterized my client as a woman with nothing. I'd like to submit 3 items into evidence." Victor Langley's smile stayed in place. "By all means," he said. David placed the first document on the judge's table. "This is the original company founding agreement, dated 6 years ago, signed by both James Hartwell and Sarah Mitchell, with Sarah listed explicitly as co-founder and 50% equity holder." Victor's smile didn't move. "That document has been superseded by." "The second item," David continued, "is a collection of 47 internal emails spanning 4 years, in which James Hartwell himself refers to Sarah Mitchell as co-founder, equity partner, and company principal, including emails sent to investors, clients, and board members." The room was a little quieter now. "And the third item," David said, walking to the clerk and handing over the USB drive, "is an audio recording made inside Viridian's headquarters, in which James Hartwell instructs his personal legal team to, and I'm quoting directly, reframe Sarah's role before this goes to court because, again quoting, she doesn't have the resources to fight this." The courtroom went completely still. Victor Langley's hand moved slightly on the table. Just slightly. His associates exchanged a look they both immediately tried to erase. Judge Harmon picked up the founding document. He read it slowly. He picked up the printed emails. He read those too. For almost 2 full minutes, the room was silent except for the sound of pages turning. Then Judge Harmon did something no one in that room was expecting. He set the documents down. He slowly removed his glasses. He stood up, and he looked directly at Victor Langley. When he spoke, his voice was quiet, but every single person in that courtroom heard every word. "Counselor," he said, "I have sat on this bench for 22 years. In that time, I have watched lawyers argue weak cases and strong ones. I have watched evidence get stretched and narratives get built. That is the nature of litigation." He paused. "But I will not sit here and watch a founding member of a company, a woman whose name is on the original agreement, whose voice is on that recording, whose 47 emails sit in front of me right now, get dismissed as a joke." Victor Langley opened his mouth. Judge Harmon raised one hand. "I am not finished." The silence in that room was absolute. "Your client," the judge continued, "appears to have spent considerable resources attempting to rewrite history. The documentation before me suggests that effort was deliberate, coordinated, and, frankly, poorly hidden. He set his glasses on the bench in front of him. I am ordering a full evidentiary review. I am also noting for the record that the conduct described in that audio recording will require separate examination. He looked at Victor Langley for one more moment. This case, he said quietly, is not a joke. Victor Langley said nothing. For the first time since I had watched him walk into that room, he had nothing to say. James Hartwell, sitting 2 rows behind his legal team, did not look up. The full proceedings took 4 more months. I won't walk you through every detail. Court cases are long and exhausting, and not the part of the story that matters most. What matters is this. The final judgment awarded me my 50% equity stake, plus damages for the period during which I had been illegally displaced from the company I helped build. James Hartwell's attempt to quietly rewrite 6 years of history fell apart under the weight of his own words. Karen Ellis kept her job. She had been protected as a witness under the court's order. David Park framed his copy of the founding document and hung it in his office. He told me later it was the first case he had ever taken to trial. Victor Langley did not laugh at anything as he left that courtroom. People ask me sometimes what I felt when the judge stood up. I didn't feel triumph. Not right away. What I felt first was something quieter than that, the particular relief of being seen accurately after a long time of being described incorrectly. Of having the truth exist on a table in front of people who could no longer look away from it. Here is what I learned from all of it. The people who laugh at your case are usually counting on the idea that you don't have one. What they don't account for is the possibility that you've been building it in silence for longer than they knew. Prepare in private. Let them underestimate you. And when the moment comes, don't argue. Just open the folder. The truth has a way of speaking louder than anyone in the room.